So, General, today you announced the formation of a civil rights team in your office. I don't need to tell you the civil rights movement dates back to the 1950s, so this isn't a new national concern. I'm wondering what prompted you now to take this step, and some might hear this news and justifiably ask, what took so long?
Yeah, well, so here's the genesis of it. When I was U.S. Attorney in the Obama administration, that administration and U.S. Attorney's Office really upped their civil rights game. Now, many of my colleagues around the country with large offices established a civil rights unit, so a dedicated group of attorneys to focus on those cases. When I was U.S. Attorney, we had 15, 16 prosecutors, and not the volume of work, frankly, at the time, which would warrant, taking 2 or 3 lawyers and putting them in a formal unit. Although we did designate lawyers to do that kind of work, and they did it then. When I got over here to the AG's office, obviously it's a much bigger office. We have about 100 prosecutors. And so in my mind from the day I took over, I certainly wanted to do more around civil rights and criminal justice reform, think about our hate crime sentencing enhancement, deploy it more often. Hadn't been used in 5 years since, when I got here. So I've been thinking about these concepts for a while. And look, the cases have been coming up. It's not like, they came up just this summer. They've come up, sort of going back in time. Even when I took office, there were some cases involving police officers back then, correctional officers that were coming down the pipeline. But what we didn't have, Tim, was a consistent group of eyes on those cases. And look, prosecutors, I've been a prosecutor for a long time. Part of what you do when you're sizing up a case is, well, how does this case compare to other cases? What law am I applying in this particular case? What is excessive force? What isn't it? And so I believe that when you bring the same sets of eyes to these cases over and over and over again, as opposed to spreading them out among 60 prosecutors in my office on kind of a one-off basis, you're going to bring consistency to it. So that was part of it. Certainly, we've seen an uptick in cases, but also, if you remember, our use of force protocol that we issued last June means we're seeing more misdemeanor cases involving excessive force than we would have seen before. And so as that volume goes up, we're going to need more resources devoted to it. We're seeing that. We've got 2 charge cases right now. There may be others. We'll see. And so, there's a greater need right now. So that's part of it. The other thing, too, is what's new about this, and has really been borne out, frankly, by some of the, in some quarters, understandable lack of trust in the independence of this office. The reality is that it's either us or the U.S. Attorney's Office that's going to be doing these cases. And there's no one else. I mean, there just isn't a construct here or anywhere else in the country to do it any other way. And so what could we think about internally to try to bring a set of eyes that aren't career prosecutors to these cases? That's why the joint investigative model, and I don't want us to lose that point, is part of this. We've had a civil rights advocate in the office since Attorney General Lynch worked to establish that position many years ago, but they've almost exclusively focused on, really not almost, have exclusively focused on civil rights, things like voting and elections and that kind of thing. What I wanted to do was to bring those sets of eyes to the review of these cases, whether they involve civilian on civilian, hate crime cases where we seek the enhancement, or excessive force cases, just to put another perspective around the table with those of us who have been prosecutors for a long time. I think that's a significant step forward.
I want to break down the different pillars of your announcement today, but before we get into that, in the news release, you were quoted as saying hate crimes in Rhode Island are on the rise. Can you quantify that?
I can't do it in terms of numbers, but I will tell you that there's no question that some of the allegations that we've heard recently, and a lot of these cases fly below the radar, Tim. They really do, because they tend to be misdemeanors. So there are incidents that are pretty plainly motivated by bigotry based on hate or gender identity. That we're seeing. And so it's pretty clear to me, again, particularly as we expand our jurisdiction into areas that involve misdemeanors, that we've got to be ready to handle those cases. Again, we typically, as you know, Tim, don't do misdemeanors, but this is one of those areas where I think sort of a consistent professional set of eyes will really be important. And look, it's not a matter of charging more cases. It's a matter of getting more cases in front of us to analyze. Where those charges are appropriate, we'll bring them. it's equally important not to bring cases where they're not. And this isn't just in this context. I think this is an important point that often gets missed. Last year in 2019 in Providence County alone, we charged roughly 6,000 cases, but there were almost 1,000 cases by my count, somewhere in the 900s, where we didn't charge cases. So in other words, state police or local police made a felony arrest. It was brought to our screening unit. And in that analytical period that can take 6 weeks to 6 months, our team decided that either it wasn't a crime at all, or it should be a misdemeanor and should be charged differently. So that analysis, that professional analysis, I think is what is so critical in this context, and of course, in every case that we analyze.
You bring up, the word misdemeanor, that some of these cases are misdemeanors and traditionally wouldn't get to your office. And it just begs this question.
Mm-hmm.
Rhode Island does not have a criminal statute specifically for hate crimes. And we'll get into it. It has a sentencing enhancement, as you referenced there. Is that enough? Or does the state need a standalone hate crime statute where no matter what the act was, that might just be a simple assault and that would be a misdemeanor? If it is motivated by hate against a protected class, that is automatically a felony. Does the state need that statute?
Tim, I haven't really thought that through. I want to hear from more stakeholders. So what a misdemeanor is a simple assault. It's a disorderly conduct. It's somebody acting up in public or in a public place or in a private place and say shouting at a person because of the color of their skin or their gender identity. Whether we need to sort of make those cases felonies is something I'd want to sort of talk to stakeholders about. There's a lot of people in the civil rights community that I've dealt with that are concerned about over felonization generally, say in the context of narcotics prosecutions. I'm somebody who doesn't believe that a simple possession of a small amount of narcotics ought to be a felony at this point in time. So I'd want to really think about that. I do think, though, that the sentencing enhancement, what can really help drive justice in cases where, whether it be a felony or misdemeanor, because the penalty is more significant in the felony context, meaning the enhancement is more significant in the felony context, that it will achieve justice, and it sends a signal to both the victim and the public of the importance of these cases and calling hate out, which is really important.
Okay, so as I said, the way I read the news today, there are 3 pillars to your announcement, and you can expand on that if you'd like. The team, the civil rights team itself, the approach to these potential cases, and the recommendation to law enforcement. I'd like to get into detail on each, but just stepping back to the average Rhode Islander who undoubtedly has a lot swirling around them right now, how would you succinctly explain your announcement today and your initiative?
Yeah, look, it's really making sure that our office has a dedicated group of experienced, well-trained prosecutors to handle these cases when they're criminal cases. It's to bring this joint investigative model to the table, meaning our civil rights advocate, today it is Keith Hoffman, a very bright civil attorney, can bring a different perspective to those career prosecutors when we sit around the table and break down a case. Is a case warranted? Is a hate crime sentencing enhancement warranted? Is this excessive force by police? That's a new perspective, which I think will really change the dynamic here. And the third thing is to make sure that police officers recognize its importance as well. So I can think of a case where the police brought the case to us a week after the incident. That's too late. If you're going to bring a hate crime, you got to bring it you got to let the defendant know that you're going to do that by the pretrial conference. That happens fast.
Explain, though, real quick on that, why that's important, because there is a clock, if I remember the enhancement, that starts ticking where you have to inform the defendant that we're going to pursue this, correct?
Correct. And that's at the pretrial conference. Remember, Tim, in misdemeanors, we're not present when the person is brought in on that misdemeanor charge. A lot of those cases are disposed of right there in the courtroom. That's a whole separate question about our justice system, but the Attorney General's office is not there. So if the police don't know to recognize a hate crime, they may dispose of a misdemeanor, disorderly conduct, or an assault, which doesn't take the hate or the alleged hate aspect of the crime into account. And so if they're not looking for it and they dispose of that case when the case is brought in for arraignment in the district court, again, we're not there. We don't have the opportunity to look at that case more closely. So we've got to have them looking for those cases. And frankly, we got to train them and we've got to be on the same page.
Let's talk about the team. First of all, I was just wondering, is the civil rights team itself diverse?
Yeah, one of the members on the prosecution side is Rob Johnson, who's a black man. Yes.
Okay, and so when they look at a case, the office or the team can pursue a case that is motivated or even partially motivated by animus towards a protected group or protected class. You know, we traditionally think race, color, national origin. Um, the two
Gender identity, disability, Tim. There's
right.
several. Yeah.
So the two avenues that can be pursued, as you touched on earlier, are civil and criminal. And I'm wondering what the line is between what you would deem a criminal case versus triggering a civil action, and also could there be parallel civil and criminal cases under certain circumstances?
Yeah. Look, I mean, in any serious case involving hate, which I think is virtually all of them, we're going to see whether we have a prosecutable case. If we do, we're going to bring it. You know, I think there are areas where I think it's important for prosecutors to lean forward. You know, public corruption is one of them. Organized crime is one of them. Hate is another one. I think it's really important that we lean forward there. By that, I mean, really look at these cases carefully. And if we can make a case, then we need to bring it. You know, on the other hand, though, there may be instances where we can't do that. For whatever reason, we can't. And then we'll use the tools in the civil toolbox, you know, which are largely injunctive relief to prevent conduct, getting a court order to prevent conduct from happening. I will say, though, that we put in legislation last year, passed by the Senate, not by the House, which would have strengthened that civil statute. So I'll give you an example. Harassment is not covered by it. It should be. It isn't. Right now, we've got to prove either destruction of property or physical violence or threats of physical violence. That is weak. It's weaker than in other states. Again, we've got to fix that statute. We've had legislation in, you know, that legislation went in, Tim, and these concepts went in long before this summer. This is something we've been thinking about for a long time from when we took office. It was a priority in that first winter. You know, pattern and practice investigations. That was a priority my first winter, where we go in and look at a police department civilly, a tool the Department of Justice has, didn't use in the Trump administration. We think we should have that tool. Again, didn't get that passed. But this is not this concept of elevating our civil rights game is not a new initiative. We've talked about this for a long time. We need more tools, but we're committed to using the tools we have right now to try to do the right thing.
You have asked each police department to designate a hate crimes and civil rights liaison who would serve as a department contact to your office's civil rights advocate and civil rights prosecution unit. You say it'll streamline information sharing among departments and your office. You can't mandate departments to do it. So what has been the reaction from law enforcement about this recommendation?
You know, we sent out that guidance to police chiefs to take a look at before we issued it, and there was no pushback. Frankly, there was not feedback. And what I take from that is they understand the importance of doing this as well as I do. Look, the reality is I don't have a lot of ability as Attorney General to force police departments to do things. I don't. Short of not charging cases that they bring to us. And as I said, that happens. You know, last year it happened 900 times. We didn't bring the same charge or any charge at all in cases they brought to us. So that's ultimately where my authority lies. But I think there is something to be said from leading from the top of law enforcement generally. And the police chiefs that we have in the state are good chiefs. They understand the significance of this and they want our help in any significant case or sensitive case or complicated case. They're reaching out to us. I just want that to happen faster. When, you know, our frustration often happens when, you know, the horse is out of the barn and we're trying to backfill. You know, I don't want to be in a position where 24 hours or the morning of a pretrial conference, the police department is saying, oh yeah, the pretrial conference is today, should we file? That's way too late. It's too late for us to do a good analysis. I don't want to be in a situation where I don't file an enhancement because I don't have enough information, or I file one that's not warranted. What's so important about this job is not to file something or not file it because the winds are blowing in a particular direction. What's so important about this job, just as it was when I was U.S. Attorney, is to apply the law and the facts fairly. That doesn't make everybody happy all the time. The only way to do that well is to get the information fast and then analyze it carefully.
The team will, as you mentioned, also look at allegations of police misconduct, police use of force. Will that only be if the alleged victim in the case is a member of a protected class?
No, no, no. So that this team meets every 2 weeks. It's already been meeting, and it already has the cases that fall within what we're announcing today. And they will go over every case that involves, these allegations. Now, they're not the only ones because I look at them too. The reality is I understand the importance of these cases. We've got a lot of pending cases in the system right now, a lot of important pending cases in the system. I have to trust my people to do them well and my managers to manage those groups. But these cases are so important that I see them all personally. So what does that mean? As a practical matter, what that means is we sit around the table virtually these days. And we look at the videos. If we have videos, we look at them and we talk about them and we discuss them and we watch them again and we watch them again. We read the law. I read the law. I want to know what the standards are. And then we talk about, well, does this meet the standard or not? That's no different. That's the model I used at the U.S. Attorney's Office on every significant case that we did, particularly public corruption cases. We sat in my conference room over there and we pulled the case apart. Are we charging the right people? Are we charging them with the right things? Or should we not be charging at all? That's the model. It works well. What's different about this, and what I think is a significant step forward, is sort of the different perspective we're going to get out of that civil rights advocate in the civil division, because he or she, if it ever changes, is not a prosecutor. They're a civil attorney. And so looking at this, the closest thing to a layman's perspective, at the same time, an experienced, very talented lawyer, I think will help us make sure that the results we're getting are the right ones.
So you said that the civil rights team has already been meeting and been doing this work. You're just sort of announcing it today. So I guess the question is the team involved in the Jamel Gonzalez investigation? And for people watching this, to remind them that Jamel Gonzalez was involved in an incident with a Providence police cruiser while on his moped. It has a ton of coverage and people remember that video. Is the team involved in the Gonzalez investigation right now?
Yes, this team is analyzing every single matter involving a police officer and a civilian, every case involving a civilian or another civilian, where there needs to be an analysis as to whether a crime has occurred or whether there's some civil action we need to take. That's the whole point. The whole point is to bring the same set of eyes to every one of these incidents. That this unit is prosecuting the Hanley case. This unit is prosecuting the Gordon case. This unit is prosecuting the Leonard case. This unit is prosecuting the other hate crimes case that we have. The reality is this is what we're doing as a team, because that consistency will drive better results. And look, there are going to be instances where we charge or don't charge cases. I get that. People are not always going to be happy with those decisions. All I can do is try to get them right. The way to get them right, in my opinion, put really good people together, make sure they're applying the same standards all the time, bring a different perspective, make sure that I have my own eyes on it, and I think we'll get better results. And when I mean better results, what I mean is, Tim, results that I have confidence in. And I think that if you're applying the law and the facts fairly, the public ought to have confidence in it as well.
What is the status of the Gonzalez investigation? When will we hear an outcome?
Yeah, look, we're nearing a point of sharing that outcome. To be candid, the fact that I'm in quarantine is not helping the timeline. It's important for me when we're done to share the results with the family first and then with the public. That's harder to do, obviously, if I'm not with my team. But we're nearing a conclusion. Whether we're able to do that in the next couple of weeks or so, or it has to wait a little bit until I'm able to get out again, we'll have to wait and see. But we're nearing a conclusion. What's taking time, frankly, is the depth of the analysis, the depth of the accident reconstruction, which takes time. The state police do a really good job there. It just takes time. And frankly, being in a position, to be able to share whatever our conclusions are with the public right away, if that's possible. So I want to be in a position where someone says, well, what happened? What did you analyze and why? And then we say, well, it'll take another month for us to get it to you. If we're at a point where we want to be able to share that, I want to be able to do that right away. And I want to make sure that our analysis is robust. So we're nearing the conclusion. But again, here's the other thing, Tim. This timeline is not unusual. It's not. I mean, I know people want answers quickly, but in every complicated case I've ever done, it's not a 1 week analysis. It just isn't. I mean, the typical case that goes into our screening unit is at least a 6-week process. You know, we had a huge backlog in this office when I took office in screening because we couldn't even keep up with that. We couldn't keep up with a 6-month process for a typical case. You know, this case isn't being analyzed in the typical fashion. I've got a unit doing it outside the screening unit process, but they still take time. I understand in some quarters the impatience, but you know, we're working really hard. And I want to make this clear. I've said to the lawyers for the family, and I've said it to the family directly when I've been in their presence, that my door is open. If you want to come in and get a status report from us as to where we are, pick up the phone, call, and come in. And and these are the words I used. That is a standing offer. Now, that was easier when I wasn't here in my home in quarantine, but we can still do that virtually. You know, we've been in regular contact, you know, with the family and the family's attorneys since they are represented, and they know exactly where we are. I know they want answers. We're working hard to get them answers as quickly as possible.
And you said you want to share those answers when you can, which indicates to me, you know, something you and I have talked about quite a bit, which is the utilization of a grand jury. When you do that, it sort of handcuffs you in your ability to share investigatory materials. Is that an indication that you're not using a grand jury in this case?
Yeah, at this point, we're not. You know, I'll only use the grand jury, frankly, for 2 reasons. Number one is if I need it as an investigatory tool. And we've talked about, you're right, we talked about this before. You know, if I need to get records I can't get, then I'll use it to subpoena it. That's how I get it if somebody won't give me information. If I can't get a witness to tell me what they saw, then I can use a subpoena to pull them in front of the grand jury. If we've got conflicting testimony that I can't resolve, I may need, you know, a grand jury of one's peers to sort of make that truth call, then I'll use it. But I'll tell you that sort of my experience now over the last 18 months has been avoid that grand jury. Look, I believe in the grand jury process. I do. I believe in it. But I understand the problem it presents in cases where there is a strong interest in the public and in the press to know what happened. So unless I need it, I'm not going to use it. If I need it, I'll use it. But if I can avoid it, I will. You know, that's why, you know, if we had my grand jury report statute, if we could ever get that passed, it would really help. I'd have the best of both worlds. Now I got to choose. So I try to make the choice based on the situation I'm in.
Just a couple of other questions here for you, and this one more sort of a functional question for your office. You referenced the backlog that you walked into. The Attorney General's office handles so many cases. People in Rhode Island, we're in our snow globe, but they have to know that Rhode Island is one of, I think, only 2 states in the country that they don't have district attorneys. So you're handling all felony cases. But now, under the Neronha administration, you're increasing misdemeanor case volume into your office through this initiative and the prior one involving police misconduct. Is that a slippery slope for you where your office is now getting involved in more and more misdemeanor cases and putting more stress on what is already a pretty maxed out organization?
Yeah, look, Tim, you're right. You know, we have our case counts are frankly absurd. You know, folks in our special victims unit are carrying over 175 cases each. And those are cases involving child molestation, sexual assault, felony domestic violence. Our drug prosecutors are handling over 200. Those numbers are almost double what they were when I was in the office. So you're right. There's a cost to the office when we take this on. You know, the reality though is if you're doing 9,000, we have 9,000 pending felony cases right now in Providence County, or maybe that's statewide, I'm not sure. Either way, it's a huge number. And we're also doing state police misdemeanors. You know, if we have to do, you know, another group of cases, then we're just going to have to do them. You know, they're important enough for us to do them is sort of where I come down on it. You know, look, every time I take on a police case, that is going to be a challenge for me. No matter what I decide, in some quarters, it's not going to be good enough. Maybe in all quarters, it's not going to be good enough no matter what I decide. But I believe that's a job we have to take on because I think we're the ones best positioned to do it, as opposed to revolving doors of municipal attorneys that can change over every time there's a local election. So look, you know, Dan Guillermo leads our civil rights unit. Okay, he led or co-led my charge to fix that backlog. Why is he in charge of this? He's one of the best attorneys in the office. He helped fix our backlog. He and Susan Urso and their team, their great team in intake, went from a 1,600 case backlog to none by June of our first year. He jumped in and helped fix that. He's now, I hope, going to lead this process extraordinarily well, and I'm confident that he will. So yeah, it's more of a load, but we'll get it done.
Quick practical question. When the civil rights team analyzes a case, will a line prosecutor still be the one in the courtroom prosecuting the case, or will a member of the team actually be handling the case itself in the courtroom?
Yeah, the team will be. So take Sergeant Hanley's case. Because of the early release of those tapes, the defendant, not surprisingly to me, filed a motion to dismiss. Mike McCabe is handling that case. He's in the unit. He's going to try that case, and he filed a really strong opposition to that motion to dismiss. So yes, the unit, Dan and the team is working on the Gonzalez matter, reviewing that matter. Rob Johnson is involved in another one of our hate crime cases. Keith is actually, Keith Hoffman, our civil rights advocate, is co-trying with John Morera, who was formerly a member of the unit before we officially formed it. He's the chief of our public integrity unit, is right today trying the Gordon case out of Barrington. So yes, this group is not only going to review the cases, but they're going to try them. That's the point. Develop the expertise, know what you need to prove a case, and then of course understand where what we have doesn't rise to the level of a crime.
Finally, for me, look, you were a longtime U.S. attorney. You know well that the federal government has a robust hate crimes statute. That was one of the options you could have taken here. You could have looked at these cases and said, pass these along to the U.S. Attorney's Office, in which you have a good working relationship with.
Yep.
And frankly, some of the penalties there are stiffer. So why didn't you take that path?
I did. The U.S. Attorney's Office is evaluating the Gonzalez case. So we do it. We talk to them all the time. John McAdams is the person I put in place as U.S. Attorney to be our civil rights liaison. He is the person over there who analyzes all of these cases. Every one of these cases, every one of them has been referred to the U.S. Attorney for a separate look. If the U.S. Attorney's Office wants to charge them, that's their call. But look, we are in regular contact with them. Every piece of documentation, for example, in the Gonzalez case, has been sent to the U.S. Attorney's Office in real time. So as we get it, they get it. They've got their own analysis to do. We've got ours. I'm a big believer in partnering with them. The choices they make are the choices they make. At the same time, I can't assume what they're going to do or not going to do. So I got to make my own analysis. So yeah, there's no hesitation on my part on involving the FBI or the U.S. Attorney's Office. Look, I think that's a great place to go. If people don't have confidence in me, I understand that. Take it up with them, see if they'll bring a different result. But I'm confident in my office. I've been in both places. I know the quality and the caliber of the people in this unit and in my administration because I hired many of them. We're going to do this the right way. I didn't come over from the U.S. Attorney's Office and kind of lose all of my federal and state experience. Steve Dambrook didn't either, and neither did Adi Goldstein. And having those two people with me at the top and this fine group of lawyers in this unit, I think we'll get good, fair results. And that's really all we can try to do.
Okay, so just follow up on that then, specific to the Gonzalez case. I was referring to all of them, but with Gonzalez, do you know if the U.S. Attorney's Office review on that is complete or ongoing?
I believe it's ongoing, but Tim, I'd reach out to them to see where they are. Certainly, I would love to coordinate with them in terms of, announcing things at the same time. Their timeline can sometimes be a little longer than ours in the state system. They have their own challenges with COVID. I think it would, the more that we are coordinating, the better. But at the same time, their independent analysis is important too. Our analysis shouldn't drive theirs and theirs shouldn't drive ours. In a sense, that's yet another set of eyes. And we'll see, whatever their conclusions are.
We covered a lot of ground. Is there anything I didn't ask you or something you want to bring up?
No, Tim, I think we covered it. Again, I think this is a much better approach to these cases than what we've had in the past. I've long believed that bringing a group of people together that really understand a topic, know the law in the area, and then getting them in a room and really pulling a case apart and looking at the law, looking at the facts, and being skeptical. I mean, to me, it's a little bit like if you're a sailor, you let your sail all the way out to see how much wind you got, and then you bring it on in and set your sail, so that you're at the right place, right? But you don't know where to set the sail unless you let the sail all the way out and see how much wind you've got. What I mean by that is we should go into every case looking to try to make a case if we can, and that's what we do. So then you know what you have, right? If you're not thinking creatively, if you're not thinking to the extent of your powers, when we do this in other contexts, too, healthcare, environmental protection, you name it, that's how you reach the right result, right? Is seeing how far should I go? Be as aggressive as you can. And then at the same time, make sure that your analysis isn't over aggressive. I don't know if I'm getting that point across very well here, but what I'm trying to say is go into any case, looking to make a case. Be as skeptical as the conduct as you can be. Think of all the ways that this conduct might rise to the level of a criminal offense. If you look at it that way, you're unlikely to miss it. That doesn't mean you charge it, but you've got to be looking at it that way. And by putting everyone around a table when you're looking at a case, well, what does that mean? What does that mean? Could this be this? Could it be that? Is this really that? I think you reach better conclusions as opposed to doing it in a perfunctory fashion by one or two people doing it. I wish we could do it in every case. We'd get better results across the board, Tim. We just don't have the ability with the volume that comes across our desk every year.